This is a debate about terminology in family law, and it's a pleasure to serve under your chairmanship, Mrs. Noakes, not least because I know you're a huge champion of families, and in the ministerial briefs you've held before when you were looking after relationships work at DWP, you understand the importance of this field of work. But I want to start by sort of talking more generally. Who doesn't love a good on-screen relationship drama? Lovers falling out, marriages breaking down, dramatic affairs of the heart, they're all stock and trade of film, soaps and the media. Sometimes when children are caught in the middle of storylines, we'll routinely hear, "I'll see you in court," or "I'm going for custody of little Johnny or little Sarah." To the possessive, "she's my daughter," and divorce being described as a battle to be won. This is hugely unhelpful to families going through the heartache of separation. And as I was a family law solicitor before I came into this place, I saw the fallout of unnecessary divisive battles, and I am often found shouting at the telly when they get the terminology wrong, and my love of Coronation Street and EastEnders probably needs to be outed here. I'm going to be writing to the producers about this report and about this debate today too, because language really matters in family law. In real life, every year around 280,000 children see their parents separate. It surprises many that the term custody should have stopped being used 30-odd years ago when the Children Act came in, yet it surprises nobody that the language of war used for separating families is damaging to all involved. With approximately 40% of all separating parents bringing issues about their children to the family court, for too long we have allowed thousands of children to be caught up in an adversarial court system. The language of the legal system is accusatory and divisive, as I've said. Parents are described as Smith versus Smith. Barristers will talk about my opponent, we refer to the applicant, we refer to the respondent, and we have dispute resolution rather than problem solving. The most important humans in a child's life are therefore immediately pitched against each other at a time when cooperation is most needed. And many years ago, while I was working for the relationship experts 1+1, I wrote an article that explained, and there's lots of evidence about this, the destructive and acrimonious conflict between parents put children at greater risk of emotional problems such as depression and anxiety. Children may develop behavioural difficulties and become aggressive and difficult. Parents do not want this. For the majority of mums and dads, separation is extremely painful and a decision not taken lightly. The well-being of their children is their main concern and often the first concern when they come in to speak to lawyers. I will give way to my honourable friend.
Can I commend the Honourable Lady? In the time that I've had the privilege of knowing the Honourable Lady, these issues often come from her with a deep interest and knowledge, and I thank her for doing that. In specifics to children and family courts, children will often associate big and complicated words without knowing the very meaning of it, but they know the impact emotionally. For example, custody in prison, being in pain, separation, being alone, and perhaps even violence. Does the Honourable Lady agree that the justice system could and must look at the choice of words, which I think the Honourable Lady is outlining, and how they might impact upon the development of young children and instill fear in the very environment that they're growing up to and the changes that they're going to potentially face?
I thank the Honourable Member for Strangford in his usually thoughtful intervention. He's absolutely right, and the language that we all use, whether that is in the media or whether it is coming from our legal system and court documents, can be changed. It won't be easy. You know, we all use terminology that is outdated, and we've been told it's wrong. We get it wrong sometimes, but it can be changed, and I think we've got to work towards that. And with that in mind, I do encourage everybody to look at the report of the Family Solutions Group called Language Matters. The FSG was set up by the eminent Mr. Justice Cobb in 2020. They're a multidisciplinary group of experts working with separated parents and children, and they're also excellent and constructive. You know, there's a lot of emotion in this area, but they're trying to find solutions, and I really recommend everybody to look at their work. But let's be honest, the court system that they're talking about and we're working within is stretched to breaking point. There was over 66,000 new cases started in the family courts in April to June 2021, which is up 14% on the same quarter the year before. The rising case numbers are increasing the pressures on courts, and the pandemic was a tipping point because so many hearings were cancelled. Delays in these cases involving children are always counter to a child's best interests. Yet, despite the best efforts of the government and the judiciary and lawyers, from 2011 to 2021, the mean duration of disputes in cases involving children increased from over 31 weeks to 41 weeks, up by a third. It's now commonplace for hearings to be cancelled at short notice, and the numbers of litigants in person are rising exponentially. This gives the judiciary an impossible task in many cases. And can you imagine how hard it is for emotionally charged parents to go through a confusing court system on their own? When I was practicing, people would save up to have 1 hour of my time because that's all they could afford, hundreds of pounds, and then they would get as much as they possibly can from me and head into the court system on their own, often terrified and desperate to do a good job. But we come back to language again with the court system, because the FSG report sets out the archaic language that's familiar to me, the judiciary and lawyers, but the terms court bundles, pleadings, Section 7 statements are alien to most people. In essence, the court should be the last resort for parents, but it's sadly often seen as the first port of call. Our system can, however, be changed so that parents who do not have legal issues to resolve should not go anywhere near a judge, particularly for child arrangements, as many cases are not about law. They're about communication or relationship issues, responsibilities, schools, hobbies, or the scheduling of a child's time once they are now in two homes. If there is no safety, domestic violence or protection issues, parents would be best served by being supported to reach agreements as early as possible outside of the court system. Now, I've said for years that I estimate about a third of private law children cases shouldn't be in court. But I defer to a brilliant judge, Sir Andrew McFarlane. I heard him on the Radio 4 programme the other day as the president of the family division. He was estimating the number to be about 20% of families could be helped outside of court. So if we're investing, or if we invested in helping 20 to 30% of families stay out of litigation, we'd not only help the children of those families, but court time would also be freed up for the families that need it most. In the case of Ree B, His Honour Judge Wildblood said, "Do not bring your private law litigation to family court here unless it is genuinely necessary for you to do so. You should settle your differences." I will give them. Yep.
Yes, thank you, Madam Chairman. As a former magistrate in the Family Proceedings Court, I completely agree that when you've got people who come for contact arrangements with their children, very often it's the magistrates who are acting the role of a mediator and helping them come to a decision within the courts. And would you agree that that is not the place for parents to come and actually have other people sort out their own child arrangements for them?
I thank you for that intervention. I do agree. It's not a good use of magistrates' time either. This is not easy for parents. Nobody should suggest that they rush to court, because often that isn't the case. At the moment, parents think court is the only place to go to get disputes resolved. So I think that change with society and culture would also help, but also help free up the court time, which is incredibly important to yourself and other magistrates as well. So His Honour Judge Wildblood went on to say, in this case, directed at parents and lawyers, "If you bring unnecessary cases to this court, you will be criticised and sanctions may be imposed on you. There are many other ways to settle disagreements, such as mediation." So I'm looking to the Minister to help me and other parliamentarians to change the family law system, to in turn help the Ministry of Justice achieve its goals in ensuring that people can access justice and court time in a timely way whenever they really need it. So I will give way. Thank you.
Lady for giving way, and I agree with what she's actually talking about. The problem can be that there are insufficient resources in mediation services, but of course if we invested in them we could make savings further down the road within the court system, within the Ministry of Justice. Is that something that she would encourage?
I thank you for your... It's absolutely fantastic to hear that intervention, to talk about mediation. There has actually been a lot of investment into mediation. The demand went up an awful lot when we had a voucher system, which we may hear from the Minister about. But it's where the demand has gone up, we need to meet that demand, because those parents are the ones that would end up in court if it is not there. So if we cannot get them into the mediation services. So it's absolutely great to hear you champion mediation in that way, and we'll look to the Minister to hear more about those options. So I'm asking for a few things today. Will the Minister confirm that the Ministry of Justice's much-needed focus on family law reform is continuing now the Lord Chancellor is back in his post? Because it went quiet for a bit, and the Lord Chancellor, when he previously there, was doing an awful lot on this. I want to know what's happened to the demand reduction plan that I know the department was looking at very carefully, and they were designing that to keep families out of court wherever possible. Will the Minister agree that the FSG should receive a formal response from the government to their reports What About Me and Language Matters? Please confirm that the department is working across government departments to embed support for separating families in services like family hubs, and to learn from DWP's successful reducing parental conflict programmes. And will the government confirm that investigating and extending family law projects and pilot schemes, because we know that they are working really well and teaching us better practice for children cases, so we'd like to see more of those. And finally, to get the FSG officials into the department to discuss their proposals. I genuinely believe that changing the options available to parents, re-educating society about the impact of litigation on children, and changing the legal language of separation will help millions of parents and, importantly, the life chances of children. I hope we can work together to make that happen. Thank you.